terrific. There's such a buzz in the room. You can hear, I think, the noise around. It's very exciting.
The central focus of the inquiry was on connection to country, which is captured in the main title of the report. It was a law reform project, but it was tackling an issue which is so transcending, so fundamental for Indigenous peoples of Australia.
I feel very proud. There's a lot of work that has gone into the report. We've built on the contributions of many people, but I also think that the report, it's one that I hope will be implemented in its various ways, and that will improve the lives of Aboriginal and Torres Strait Islander peoples.
The Law Reform Commission's got a terrific record of producing very valuable research reports and recommendations for the future. It's a great report to be launched in the 40th year of the Law Reform Commission, and I just hope that people read it in the spirit in which it's been drafted and build on the experience of the past 20 odd years to make for a better future for native title.
Out of this report, I would hope that the recommendations would be accepted and that the Native Title Act could be amended to ensure that the process is easier to understand for Aboriginal and Torres Strait Islander people and that the process runs more smoothly.
The ALRC recommends that the basis of native title as set out in Mabo and as reflected in the statutory definition of native title should be preserved. However, the definition in the Native Title Act should be amended to clarify that traditional laws and customs may adapt, evolve or otherwise develop. Further, that acknowledgement of traditional laws and observance of customs need not have continued substantially uninterrupted since sovereignty, and the corollary that acknowledgement is not required by each generation since sovereignty. Further, it is not necessary for claimants to demonstrate that a society united in and by its acknowledgement of traditional laws and customs has continued since sovereignty. And finally, in this package of reforms, native title rights and interests may be acquired by succession. The ALRC recommends that the definition of native title in the Act be amended to confirm the principle that a broadly framed native title right may be exercised for commercial purposes. I'd like to turn now to the third group. So these deal with authorisation and the provisions of authorisation under the Native Title Act, and then the final group. And these relate to what are known as joinder or party provisions under the Act. And it's basically the means by which other persons become involved in a native title determination.
The ability of these amendments, if they're adopted, will be to enable people to engage in a simpler way and in a more cost-effective way.
In terms of the nature of this particular report, I think this is very much consistent with the spirit of the times when it comes to the advancement of Indigenous people, which is that we give them the tools to advance themselves, that we strengthen the foundations of economic development.
I hope that it can mean a renewed faith in the Native Title Act process. I think that is important not just for Aboriginal and Torres Strait Islander people themselves, but also for the Australian community. And I think that the steps forward in terms of economic and cultural sustainability are important ones, and that this report will be a firm foundation building into other initiatives in that area.
I'd like for Aboriginal and Torres Strait Islander people to understand the process and for the process to make sense to us in terms of justice and land justice and rights.
I would like to thank the large number of people who contributed to the report. We were fortunate in being able to consult with members of the Federal Court, and we also had the benefit of the experience of a number of members of the judiciary. Members of the native title representative bodies and native title service providers, despite suffering reform fatigue, also gave the benefit of their experience. We also had the benefit of the views of a myriad number of Aboriginal and Torres Strait Islander peoples.
The depth of engagement in this process is the hallmark of what we regard as best practice law reform, and also for the ability of governments to implement what we have to say. Everyone here today has played a part, And on behalf of the Australian Law Reform Commission, may I thank you all.